I have a quiz on California statutory construction principles used by the courts of this state. The quiz is basically to test your knowledge at a basic level about some of these principles. Question 1. The purpose of statutory construction is to determine what the legislature intended when enacting the statute in question. And that's true. According to the California Supreme Court in Smith versus Superior Court, they said, quote, the fundamental task is to ascertain the legislature's intent so as to effectuate the purpose of the statute. Question 2. An extrinsic analysis is one in which the bill language itself is interpreted by the reviewing court. And this is false. That's actually an intrinsic analysis. Question 3. A general statute always applies over a specific statute. That's false. If a specific statute is deemed to be inconsistent with a general statute that covers the same subject matter, then the specific statute is usually deemed to be an exception to the rule provided by that general statute. Question 4. A more recently enacted statute is given more weight than an earlier enacted statute. And that is true. If two statutes cannot be reconciled and appear to be in conflict, then the most recently enacted statute will take precedence over the earlier enacted statute. Question 5. Courts give reference to each word in a statute, and qualifying words are applied to those immediately preceding them. That's true. It's called the last antecedent rule. And the last antecedent rule provides that any qualifying words are to be applied to the words or phrases immediately preceding the qualifying word or words, and are not interpreted as extending to other words. Question 6. The word shall and must are used interchangeably in California statutes. And that's false. Only the word shall is used to mean something that is mandatory in California statute. The word may is deemed permissive in California statutes. And that's true. The word may generally means the matter is permissive. Question 8. A statute which lists specific items will prevent the inclusion of other items. And that's true. This is a general rule of statutory construction. Question 9. California statutes are presumed to apply prospectively rather than retroactively. That too is true. It's, again, a general principle of statutory interpretation here in the state of California. Question 10. The courts can presume retroactivity of a statute by what we call implication, and that's false. The presumption is against retroactive application unless the legislature has plainly determined by an express statement or other indicia that it was their intent to apply the statute retroactively. Question 11. As a general rule, in reviewing the text of a statute, the courts will look to the statute's ordinary or plain meaning, the words contained in the statute, that is. And that's true. The ordinary or plain meaning is reviewed unless the term is defined in the statute or perhaps if it has a specialized meaning. Question 12. A statute should be read in isolation in order to fully understand the meaning of those words that are used in the particular statute. And that's false. California courts generally read a statute in the context of the rest of the statutory scheme in which that statute or those words are found. Question 13. A general term that follows an enumerated list of more specific items should be interpreted to cover only those matters that are similar to those that are specified. And that's true. This canon is called ejusdem generis. Question 14. The expression of one thing implies the exclusion of others. And this canon means that if a statute contains a list of specific items, then those items not listed are excluded. And that's true. This particular canon of construction is called expressio unius est exclusio alterius. Question 15. The courts will read a statute that renders any words or phrases in the statute meaningless if they don't impact the rest of the statute because the legislature intended that particular result. And that's false. Here we use the canon called the rule against surplusage. And basically, the rule against surplusage provides that courts will avoid a reading of a statute that renders any words or phrases in that statute to be meaningless or extraneous. Question 16. Cognizable legislative history includes documents that the courts accept as evidence of legislative history or intent. And that's true. The biggest case is called Kaufman and Broad Communities. It was a decision of the Third District Court of Appeal, and it describes which materials are considered cognizable legislative history and therefore acceptable to the courts. Question 17. The rule of lenity is used by the courts to explain why a criminal defendant can be found guilty with less than a unanimous jury. And that's false. Actually, the rule of lenity is a canon which basically says that any ambiguity in a criminal or penal statute should actually be resolved in favor of the criminal defendant. Question 18. A statute will be interpreted to avoid serious constitutional questions if such an interpretation is fairly possible. And that's true. And this is the canon of constitutional avoidance. Question 19. Legislative history and intent materials can only be obtained by the California legislature. And this is false. The California Legislative Information website provides relevant historical and intent documents of the legislature since 1993 online. And then the state archives has materials prior to that date. Also, there are some private vendors who, if you pay a fee, can gather legislative materials. For example, Legislative Intent Service, Inc. And finally, question 20, courts can take judicial notice of proper legislative history materials. And this is true. The courts can take judicial notice of proper legislative history materials if the materials are deemed cognizable legislative documents. And again, you can look to the Kaufman and Broad decision in that regard.